Docket 25516 FC, People of the State of Michigan versus Siobhan Hanks. Counsel, your appearances for the record.
Good afternoon, Nicole Matusco on behalf of the people.
Good afternoon, Your Honor. Jacob Sarts, the fourth Assistant Public Defender, here on behalf of Mr. Hanks. He's present at the podium. He's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. This is a motion to reduce bond. Is that correct?
That's right, Jen.
That's correct, Your Honor.
Prior to this, sir, however, you seem like such a nice young man. I've read your history. It's not the worst, but you have a few things that are not so nice as well. What is troubling to me, before we even get to this motion, is that I do not let anyone, and I mean anyone, disrespect a public defender, disrespect a prosecutor, law enforcement, or anyone in my office. I have a staff of letters that you have written to a prosecutor who does an outstanding job. I will read some of it to remind you of the disrespect that you have shown. Here's a letter that starts out, "Hey, bitch Matusco, it is Siobhan Hanks writing to again. This case has been going on for over 13 months now, and still not a plea deal been offered to me." It goes on. Here's another letter. "Hey, bitch Matusco, this is Siobhan Hanks writing your bitch ass again. Still no motherfucking resolution. Huh, bitch? It is not hard for you to figure the fuck out what you want to do with me, bitch Matusco. This case is petty as fuck. This case is so fucking frivolous, okay? Yes, I know I did something wrong, but this is not some type of big case. This is not an average armed robbery. All I did was use a punk-ass BB gun to take a punk-ass dab pen and a punk-ass breeze while I was high on multiple different drugs. Bitch, stop playing and give me rehab with probation. Do not even offer me any prison time because I am not taking it. So with that being said, bitch Matusco, I need some type of plea deal with no more upfront jail time immediately." Goes on to talk about other things about the plea deal, and then said, "I did shit to people who did less than what you are doing. So fat funky bitch, hurry the fuck up. It is time we wrap this case up. And when you bring these letters up in court, mention my reason for them. Oh yeah, I do not give a fuck about you reading these letters in court. Go ahead, I want you to. No fucks is giving." Oh, it doesn't stop there. Do not know why the fuck you have not dropped my charge down to unarmed robbery or larceny from the person I truly did learn my lesson. Nobody got assaulted. I was high on a few different drugs at the time of the incident. I only did that for a breeze and dab pen. I clearly have a drug problem. I have over a year of jail time served. I am open to accepting rehab and intense probation, bitch. Again, more vulgarity. "I do not give a fuck about you telling the judge about these letters. The fuck you can show her shit. You can read this shit in courtroom for all I care, or should give me all letters I wrote you, and I will read them in court with a big smile." I don't see you smiling now, sir. And I suggest you don't, because this isn't very funny. "I am not scared of you, nor the rest of them crooked bitch-ass prosecutors that work at your office, including y'all master, John Dwayne." Oops, let me check myself. I mean, bitch Dwayne, y'all can suck the cum out of my big black dick. Fuck every business building on Kalamazoo Street, along with the whole Michigan Avenue bitch you trying to send me to prison over a BB gun, breeze, and dab pen. The victim was not assaulted. That shit is not worth any prison time. And it goes on. You owe the prosecutor an apology. You will not write these letters. You do not have the right to assault verbally the prosecutor or your attorney or anyone in this courthouse. None of us are in handcuffs. You are. You need to check your attitude and think kindness. These words are fighting words. They're assaultive and very disrespectful. Let me remind you, these are not small charges. And I don't even have a police report, but I'm looking at these charges. Count 1, armed robbery, is a felony punishable by life or any term of years. Count 2, weapons, dangerous weapon, carrying with unlawful intent, felony, 5 years or $2,500. Count 3, weapons, felony, firearm, pneumatic gun. And I don't have what that, just apparently doesn't have what that is. Is that a 2-year?
Your Honor, it's a mandatory 2-year consecutive to the underlying offense.
Yeah, that part's missing here. But anyways, I thought it was a 2-year. It's a 2-year. These are some pretty big charges. And it is only a small man who uses those words against a woman or against anyone. Those words do not make you strong, they make you weak. And it's very disappointing, sir. You have a mother?
Yes, I do.
You love your mother?
Yes.
How would you like it if somebody wrote those words to your mother?
I would not. I wouldn't like it.
Then what were you thinking?
I was angry. Case been at a standstill for a year and a half. I know it's not a good excuse, a good reason of why I did it, but I just been in a dark space mentally, just ready to get on with my life. I learned a big lesson, just being locked up, just ready for a resolution.
Sir, I'm here every day. Law enforcement, even on vacation, will call me. The jail will call me 24/7. I'm not unknown. Your attorney in his office is not unknown, and neither is the prosecutor's office. If you had a problem, you tell the sheriff. The sheriff's going to call us, one of us, all of us, and we're going to help you. These letters hurt your case. If you think that I am going to entertain a bond after I read those angry words, those fighting words, the answer is no. So y'all can make your record, but when I look at this, I look at danger, I look at threats, a lot of anger. We're gonna get this resolved. I don't know what's going on here. I think we've had a few pretrials, haven't we?
We have a final pretrial and a trial date set. We have our final pretrial set for mid-March, Your
I think
Honor.
it's March 11th, Your Honor, we're the final pretrial with a trial date in April.
So shall we have the final pretrial? And in regard to these letters, I'm thinking maybe we have contempt. These are threatening. Contempt carries with it 93 days and or $7,500.
Well, Your Honor, we are still attempting to negotiate a plea offer here. I would simply respectfully request that we keep that window open until that March 11th date. It's my understanding that Madam Prosecutor would like to meet with the complaining witness again and then extend a final offer. We have been negotiating in good faith on both sides. Certainly, Mr. Hanks' alleged statements here have added another layer of complexity here to the negotiations, to put it mildly, understated. But respectfully, Your Honor, we are making every effort. I'm making every effort on my end. So is Chief Deputy Matusco, to try to see if we can find some common ground here to resolution before a potential trial date, which we have set. And I will be prepared and able to proceed with the trial on that date if needed, Your Honor.
Ms. Matusco, are you asking for contempt?
Your Honor, this time I would be asking the bond be revoked. We are set at $250. I believe the court rule allows it. The court did not read into the record the final statement on the final letter that I did receive in January. And that was—
Which one is that?
I don't know if yours are in the same order, but it says, P.S. I did a lot of bad shit to people who did less than what you are doing to me right now. Bitch, you better be safe. That ain't no threat either. That's a direct threat to
That is a direct
the prosecutor here. It's not that we're using angry words. It is that we are literally threatening. And this has been Mr. Hanks' consistent MO whenever he doesn't get his way. So rather than asking the court for contempt, it is my intention when I make my record as to the conditions for pretrial release to ask this court to simply revoke bond. So there's no way he gets out prior to that traffic.
I don't know how I missed that. I was just so appalled reading all of it, but it is also in capital letters, what you just read. P.S. I did a lot of bad shit to people who did less than what you're doing to me right now. Bitch, you better be safe. That's all capital letters. Capital letters means anger and it's threatening. Under it, it says that ain't no threat either, meaning it's gonna be a real issue. Is how I read that. Like you're gonna make good on it, not a threat. Bond is revoked. Any more letters, bad behavior, every single letter, every single bad behavior will be in 93 days. Contempt. Consider this a huge warning. Sir, you can't treat people like that. I don't know what anger issues you got, but we're gonna get you some treatment, mental health treatment in jail. Because if you continue this path, you're gonna be in prison. You're not doing yourself any favors, you're not keeping our community safe. Your anger is getting the best of you. You've been in front of me before, you've always been respectful. So I don't know what's hard. I am sure that it's very difficult being young and in jail. But you see, we have a retail fraud, height was revoked. You have defrauding an innkeeper. You have CSC fourth degree by force or coercion. We have, do we have a pending charge? We have 2 files.
Your Honor, the pending charge was when he was out on tether. He cut his tether and was found in possession of cocaine. So the pending charge is having cocaine in his pocket.
So you got drugs, and you've already acknowledged in here that you were high and not making the best decisions. So you gotta address these issues, and we're gonna have that happen in jail right now. Is there a final offer, or are you still working on that?
Your Honor, it's my intention to meet with the victim in this matter. We've been working around work schedules and my own personal schedule within the next week so that I will convey that final offer.
I have a final pretrial this last September, so I don't know what happened, but I know there's been a lot of changes and other things that have happened, so.
Your Honor, I can address that.
Okay,
Previously, this case was being handled by Dale Caldwriter from my office, who was the assigned prosecutor in this case. Mr. Hanks made the decision to write him letters as well. So when I was covering this court, I took this case over to remove Mr. Caldwriter from the file to hopefully stop those letters from happening. Those are not attached to this motion, as I only wanted to update the court as to what has transpired since the last time this court denied bonds. And it's clear that the letters were getting more threatening once they were directed towards me. So I took this case over in September. Mr. Swartz and I began negotiating, exchanging information, mitigating information, discovery, to see if we could get a resolution in this case. So that's why that final pretrial was adjourned back in September.
all right, March 11th, final pretrial, you're here,
Yes, Your Honor.
and then when is the trial?
It's April 24th.
Probably 4 or 5 scheduled that we did, and I don't think that, I think a couple of them are older than this, so we need a couple backup dates unless you want to prioritize this because he's in lockup.
I will work with Mr. Buxton to see where we are on the list and then communicate that to Mr. Sartz as well. If a backup date is necessary, Mr. Sartz and I can work the schedule to get one.
You're remanded to the jail, you're gonna work with community mental health, see medical, psychological, go to CATS, get some treatment over there, sir. This cannot continue. I know you don't like jail, but you gotta change what you're doing out in society, or you're gonna be in jail, and then you're gonna be in prison. And this has not made me happy to do this to you, but I don't know what else to do. We have public safety. And I'm fearful if I were to let you out again, it would get worse. So go into jail and work on what you need to work on. And there'll be no more letters like this. Otherwise, it's 93 days, every single letter. And that does not count against any other sentence. That is separate crime. Have I made myself clear?
Yes.
Do you have any questions about what I mean?
No, I understand.
Is there anything that you need over in the jail that you're not getting?
No, can't think of anything.
Quickest way to get out of jail is to behave. Start working on your rehabilitation. Talk to your attorney. Don't be rude, crude, angry. We didn't commit the crime. You're innocent until proven guilty beyond a reasonable doubt, but for bond conditions, I have to look at public safety. What I see here is not safe. You're entitled to your trial and you're gonna get one. But I also want you to consider these letters that you admitted bad behavior, criminal behavior. So I don't know how that's gonna play in. But you didn't do yourself any favors, sir. You said who you were, you wrote these, and you talked about what you did. Those statements can all come in at trial. There's any pretrial notion about motions that this isn't gonna come in. Set it in front of me, but I don't know how you get around this from coming in if people wanna bring it in. You can talk about that with your client, you need to talk about that with your attorney. Have I made myself clear, sir?
Yes, you have.
Very good. Is there anything else we need to address?
Yeah, Sharon, I believe we addressed it at the December court hearing. The no contact order for a witness, well, sometimes a co-defendant. I know Mr. Starks and I have worked to get her an attorney appointed because some of the letters implicate her as well. I just want the court to reaffirm that no contact order and make it clear to Mr. Hanks that that includes reaching out by way of a third party. He recently made phone calls to a third party to make contact. That third party did cut him off, would not engage in much of a conversation, but I just want to make it clear that any contact, whether directly or indirectly with Ms. Hill, would violate this court's order.
Do you understand the no contact order? And Ms. Hill was already added. I have a note here, a potential witness, and she may have some culpability. We need competent counsel for her.
And
So-
and she may have some culpability.
Culpability, and we need competent counsel for her. So I don't know if that's occurred. It should have. This is my notes from last year.
It has, Your Honor. I believe the public defender's office was quick to provide her with competent counsel.
Sir, no contact with any witness, defendant, victim. You're not doing yourself any favors. Taking all your anger out on yourself. The only one you're hurting is yourself. Stop doing that. Help your attorney provide a defense. That's your job.
And Your Honor, that would include third-party communication or handwritten letters that I will note for the record are scanned by the jail.
Are you gonna have trouble not complying? Are you gonna have trouble complying, I should say?
No.
You understand no communication through third party? You understand what that means?
Yes, I do.
No contact means you don't exist in your world. No carrier pigeon, no smoke signal. No Hallmark cards. No letters, phone calls, email, text. Contact through third parties. They don't exist in your world. Have I been clear, counsel?
Yes, Your Honor. Thank you.
Any questions?
No.
That's all for the record. Thank you.
Thank you, Your Honor.
The hearing centered on a motion to reduce bond for Jun Hanks, but quickly turned into a much broader and more serious discussion about his conduct while in custody, the threatening letters he had sent to the prosecutor, and the court's growing concern that he posed a danger if released. At the start of the proceeding, the judge noted that although Hanks appeared polite in court and his record was not the worst, there were troubling issues that had to be addressed before the bond motion could even be considered. The judge made it clear that one thing she would never tolerate was disrespect toward public defenders, prosecutors, law enforcement, or anyone working in the court. She then explained that she had received a stack of letters Hanks had written to the prosecutor, letters that were filled with profanity, insults, and threats. To make the seriousness of the situation unmistakable, the judge began reading portions of those letters aloud in court. The letters showed Hanks repeatedly writing to the prosecutor in vulgar, abusive language, complaining that his case had been going on for more than a year without a plea deal. He demanded immediate resolution and belittled the case, describing it as petty and frivolous. In one letter, he openly admitted the underlying conduct of the case, saying he used a BB gun, take a dab pen, and a vape while he was high on multiple drugs. He insisted that because the incident involved what he saw as minor items and because no one was assaulted, he should receive rehab and probation rather than prison. but his requests were buried under a stream of crude insults directed at the prosecutor personally. He called her degrading names, ordered her to hurry up and resolve the case, and repeatedly said he did not care if the letters were read in court. In fact, he taunted the prosecutor to bring the letters up before the judge and claimed he would happily read them himself in the courtroom with a smile. The judge, however, pointed out that he was not smiling now and made clear there was nothing amusing about what he had written. As the judge continued reading, the tone of the letters became even more disturbing. Hanks insulted the entire prosecutor's office, called the prosecutors crooked, used sexually explicit and degrading language, and ranted about the idea that he was facing prison over a BB gun, a vape, and a dab pen. The judge emphasized that these were not harmless outbursts, but fighting words that were deeply disrespectful, aggressive, and abusive. She told Hanks that he had no right to verbally assault a prosecutor, his attorney, or anyone else in the courthouse. The judge reminded him that while he may have been frustrated, the people he was attacking were doing their jobs, and none of them were the ones in handcuffs. In her view, the letters reflected not strength but weakness, and they raised serious questions about his anger and his ability to control himself. She was particularly troubled because the target of the letters was a woman who was simply trying to handle the case professionally, and she told him bluntly that a man who speaks that way to a woman or to anyone else is not acting tough. He is acting small. The judge then shifted to the underlying criminal charges and stressed that Hanks was badly underestimating the seriousness of his case. She noted that he was charged with armed robbery, which carried potential life sentence or a term of years, along with a charge involving carrying a dangerous weapon with unlawful intent, and a firearm-related charge involving a pneumatic gun that carried a mandatory consecutive 2-year term. Although Hanks had written in his letters as if the case was trivial, the judge made clear that these were significant felony charges and not something a court could casually dismiss. She connected this to the tone of his letters, explaining that someone facing serious violent charges who was simultaneously sending profanity-laced threats to the prosecutor was not presenting himself as a candidate for leniency or release. From her perspective, his own words were undermining his case and painting a picture of someone angry, impulsive, and potentially dangerous. When the judge asked Hanks whether he had a mother and whether he loved her, he answered yes to both. She then asked him how he would feel if someone wrote such vile, degrading things to his mother. Hanks admitted he would not like it. Pressed to explain why he wrote the letters, he said he had been angry because the case had been at a standstill for about 1.5 years. He acknowledged that anger was not a good excuse and said he had been in a dark mental space. He claimed he had learned a lesson from being locked up and that he was desperate for resolution so he could move on with his life. He also suggested that his frustration had built up because he felt stuck in jail without progress in the case. The judge did not dismiss the difficulty of incarceration, but she told him there were proper channels to raise concerns. If he had a problem, he could tell the sheriff or communicate through appropriate means, and someone from the court system or the jail would respond. Writing obscene, threatening letters to the prosecutor was not an acceptable outlet. At that point, the judge made it clear that the letters had destroyed any chance of favorable ruling on the bond motion. She said that after reading those words, there was no possibility she would entertain bond reduction. When she looked at the letters, she did not simply see frustration. She saw danger, threats, and uncontrolled anger. The court then turned to the procedural posture of the case. Defense counsel explained that there was a final pretrial scheduled for March 11th and a trial date set for April 24th. He noted that the parties were still attempting to negotiate a plea in good faith and that the prosecutor wanted to meet with complainant witness before extending a final offer. Defense counsel asked the court to keep that negotiation window open until the March pretrial. He acknowledged that Hanks's letters had made the situation far more complicated, but insisted that he was still working hard to see if a resolution could be reached before trial. The prosecutor, however, took a much harder stance in light of the letters. She said that rather than asking the court for contempt immediately, she was asking for Hanks's bond to be revoked entirely, so there would be no possibility of release before trial. She pointed out that the judge had not yet read the most chilling line from one of the letters, a postscript written in capital letters in which Hanks said that he had done a lot of bad things to people who had done less to him than the prosecutor was doing, and that she better be safe. The prosecutor argued that this was not merely angry language. It was a direct threat. She explained that Hanks had a pattern of acting this way whenever he did not get his way, and that in her view his conduct warranted revocation of bond rather than just a contempt warning. Once the judge heard that specific passage, she agreed it was highly threatening. She emphasized that the line was written in all capital letters, which to her signaled anger and menace, and that the phrase "that ain't no threat" either suggested not a denial, but an implication that he intended to make good on what he was saying. At that point, the judge revoked bond. The judge then issued a stern warning that any further letters or similar misconduct would result in contempt proceedings, with each act potentially carrying an additional 93 days in jail and a fine. She told Hanks that he could not treat people like that, and that the court was now deeply concerned not only about his case, but about his mental state and anger issues. She said he needed treatment, and that while in jail he would be ordered to work with community mental health, see medical and psychological staff, and receive whatever services were available. The judge told him plainly that if he stayed on the same path he was on, he would end up in prison. She stressed that he was not doing himself any favors, that his anger was getting the best of him, and that he was not keeping the community safe. She also noted that he had appeared before her in the past and had always been respectful, which made this behavior even more alarming. To her, something had changed, and whether it was drugs, anger, mental health issues, or all of the above, it needed to be addressed immediately. The judge then reviewed Hanks's broader criminal and supervision history to explain why she saw him as a public safety risk. She referenced a retail fraud matter in which his bond had already been revoked, a charge of defrauding an innkeeper, and a fourth-degree criminal sexual conduct case involving force or coercion. She also referred to a pending cocaine case that arose when he had previously been out on tether, cut off the tether, and was later found with cocaine. In the letters themselves, Hanks had admitted he was high on multiple drugs when the alleged robbery occurred. Taken together, the judge saw a pattern of substance abuse, poor decision-making, non-compliance with supervision, and escalating anger. She concluded that these were not isolated incidents, but signs of a person whose problems were intensifying. For that reason, she believed jail was the only safe place for him at that moment because it would allow him to receive treatment while preventing further danger to the public or the people involved in the case. The prosecutor then gave more context about why the case had dragged on and how the letters had affected it. She explained that the matter had originally been handled by another prosecutor, Dale Calrider, but Hanks had written letters to him as well. Because of that, when she was covering the court, she took the case over in September in hopes of stopping the letters and stabilizing the process. Since then, she and defense counsel had been exchanging discovery and mitigation information and trying to negotiate a resolution. She explained that this was why the pretrial date had been moved back. She also indicated that she intended to meet with the victim soon and then convey a final offer. The judge accepted that explanation, reaffirmed the March 11 final pretrial and the April 24 trial date, and noted that because Hanks was in custody, the court might need to prioritize the case or set backup dates to ensure it moved efficiently. Even after revoking bond, the judge tried to speak to Hanks in a direct but somewhat rehabilitative way. She told him that jail did not have to be wasted time and that the quickest way out was to behave, start working on rehabilitation, and talk productively with his attorney. She reminded him that he was presumed innocent until proven guilty beyond a reasonable doubt, and that he was entitled to a trial. But for purposes of bond, the court had to focus on public safety, and what she saw in the letters and in his history did not suggest safety. She also warned him that he had badly damaged his own legal position because in the letters he admitted who he was, admitted writing them, and made statements about what he did in the underlying case. The judge told defense counsel that these statements could become an evidentiary problem because they might be admissible at trial, and that Hanks needed to understand the consequences of what he had put in writing. The judge essentially explained that even beyond the bond issue, his own words could now be used against him, making his defense more difficult. Another important issue addressed during the hearing was the no-contact order involving a witness or co-defendant named Miss Hill. The prosecutor asked the court to reaffirm the no-contact order because Hanks had recently tried to reach her indirectly through a third party. According to the prosecutor, that third party cut him off and did not engage, but the attempt still raised concerns. The judge recalled that Miss Hill had been identified as a potential witness and might also have some culpability in the case, which was why conflict counsel had been arranged for her. Once it was confirmed that she did in fact have counsel, the judge turned back to Hanks and made the no-contact order extremely explicit. She told him he was to have no contact whatsoever with any witness, defendant, or victim, including Miss Hill. She emphasized that no contact did not just mean no direct contact. It also meant no indirect contact through other people. He could not use third parties, letters, phone calls, emails, texts, or any other method to reach her.